Ma'am, 32 and Article 7.0. Are we ready to proceed?
Yes, Your Honor.
Good morning.
Good morning. May it please the court. My name is Janelle Weber, and I have the privilege of representing the appellant Ignasio Sallaya. I would like to reserve 4 minutes for my rebuttal. Your Honor, Your Honors, the appellant Ignasio Sallaya had the unfortunate success of being the successful bidder at a foreclosure sale. He was not accustomed to bidding on real property at foreclosure sales, and when he won, he was not aware of the fact that there was a superior mortgage that was in place. And when he bid the $150,000, unfortunately, that left him with nothing because the property already was encumbered.
Is there any dispute that had he done a property search would have revealed that mortgage?
That particular fact is not in the record. However, the notice of Lis Pendens in the equitable lien foreclosure, it was filed. However, I would note that it did say that it was for a partition of property. And that's an interesting fact because it certainly wasn't for a partition. It was to recover funds on these alleged garage door services that were performed.
There's no dispute in the record that the prior mortgage was previously recorded in the official record book, correct?
Yes, the mortgage was recorded.
And there's no record evidence that there was ever satisfaction mortgage filed prior to foreclosure actually gave rise ultimately to your client's successful foreclosure bid.
That's correct. It had not been satisfied. And we are asking that the court apply de novo standard of review here because there's a lack of subject matter jurisdiction. And we are arguing it pursuant to the persuasive authority of the Quatermine line of cases from the 4th District Court of Appeal. If a de novo standard of review is not applied in other situations involving appeals of a foreclosure sale, the abuse of discretion standard is sometimes applied in those other cases. However, we submit that that is not appropriate in this case because we're not arguing that there were particular fraud or other defects in the foreclosure sale. It was simply this lack of subject matter jurisdiction. But under either standard of review, this court should hold that the equitable lien foreclosure judgment was void, and therefore the foreclosure sale was also void.
Our district has never held that the Lis Pendens statute 4823 is a jurisdictional statute, correct?
I have not seen a second DCA case under that
So
authority.
we're under marching orders now for Supreme Court that we're applies supremacy to text principle. What do you read in 4823 that tells you this is a jurisdictional bar and not just simply a statute that defines the parameters of what property interests will or will not be affected by the Lis Pendens? It seems to me the legislature knows how to ascribe and withdraw jurisdiction in other contexts, other statutes. I'm not seeing that in the LP statute, so help me out textually where you're getting it from.
It constitutes a bar to the enforcement against the property.
So it's statute of limitations. Instead of jurisdictional, you say it's a defense.
Well, the Ad Hin case from the Florida 5th District Court of Appeal, they phrase it as a jurisdictional statute of non-claim. So I would say there's a difference between a jurisdictional statute of non-claim, as they explain, and a statute of limitations. With the jurisdictional statute, the court doesn't have any discretion, and it is completely barred, and they cannot bring any such claim. Obviously, with the statute of limitations, it would be an affirmative defense that could be waived. So under the fourth DCA cases, they continually mention the word jurisdiction. I would also refer to an old Florida Supreme Court case, DePass versus Chitty, that it defines Lis Pendens, and it says the doctrine of Lis Pendens is defined as the jurisdiction, power, or control which courts acquire over property involved in a suit, pending the continuance of the action and until final judgment therein. And there's also the May versus Illinois National Insurance Company case that states that one untimely claim filed pursuant to a jurisdictional statute of non-claim is automatically barred. Another example of a jurisdictional statute of non-claim would be 733-710, as I mentioned in my brief. And it's certainly not lost on me that county courts have jurisdiction for amounts of controversy up to $50,000. We're not disputing that, of course, but we would submit that 48.23 does narrow the scope of available jurisdiction for parties with unrecorded interests in real estate. I would like to mention a little bit about that first phrase in the statute, except for interest for persons in possession. That was discussed in the answer briefs. That phrase doesn't apply here because BAM 32 was not in possession. It was allegedly a vendor that performed these garage door services, and therefore we would not have that exception to filing the intervening in the superior mortgage foreclosure within that 30-day time limit. So cases in which that phrase were discussed, cases like the Adhin versus First Horizon Home Loans and Townsend versus Fox, they discussed whether that particular party was in possession. And in Adhin, the party was not in possession, and in Townsend, the party was in possession. So in none of those cases would they apply to a party in the same posture as BAM 32. It is true that we don't have a transcript in this case. Obviously, we would prefer that we did, but that is not fatal to this case because the foreclosure judgment and the order that we're appealing here today, denying the amended motion to vacate, they're flawed on their face because of the lack of jurisdiction. There was an evidentiary hearing, that is true, but we are not arguing based on any of the evidence that was presented in testimony as to any particular alleged fraud that was in the foreclosure sale. That was not the subject of the amended motion to vacate. It was simply a legal argument, and the trial court was well aware that there was a superior mortgage foreclosure. There was a motion for judicial notice that was filed. So the court had all of the original final judgment of foreclosure in front of it. It was also submitted into evidence. And for that reason, it's very cut and dry from our perspective that the foreclosure sale and final judgment of foreclosure were void. And the court doesn't need to look into any particular evidence that may have been testified to on that particular day, the evidentiary hearing. So we are asking that the court reverse the trial court's order and hold that the foreclosure sale must be set aside, and that the final judgment of foreclosure is void, and that the funds that Mr. Sallaya bid, that those should be dispersed back to him. Does the court have any more questions?
No.
No?
Thank you.
All right, I'll reserve for rebuttal. Thank you.
Well, 4 or 5, we have 5.
5 would be great.
All right. Good morning.
Good morning, Your Honors. May it please the court, Eric Delatour here on behalf of appellee BAM 32. I'm joined by the co-appellee, RE 710, represented by Mr. Wolf. We are going to split our time today, 10 minutes and 10 minutes. I am going to address the appellant's lack of standing to even raise these arguments here today, as well as the lack of record. Mr. Wolf will address the subject matter jurisdiction arguments that have been raised. So as we know, the appellant was the successful purchaser of a foreclosure, a property at mortgage foreclosure. They have now filed a motion to vacate judgment, asking this court to vacate the judgment. They are not a party to the case. They have not sought intervention into the case, yet they are asking the court to vacate a judgment of which they were not a party to. They claim in their briefs that they derive standing to even raise this motion two different ways. The first way is via the Quinn Plumbing Company v. New Miami Shores court case, in which they claim that they can be the equitable assignee of the plaintiff. However, that case is distinguishable from this. In that case, there was a mortgage foreclosure. The plaintiff missed a junior interest, and the court allowed the third-party purchaser to come back into the case as the equitable assignee of the plaintiff and foreclose out a junior interest. There is no discussion in that case whatsoever about whether or not that equitable assignee can then vacate a judgment that they were not a party to. Next, the appellant says they are a quasi-party to this case. They cite the Miller v. Stavros case as their authority to act as a quasi-party. However, that case is also distinguishable. That case only handles post-judgment, post-sale issues. They're allowed to act as a quasi-party to handle a disbursement of surplus funds. Again, there is no reference whatsoever to vacating a judgment for which they are not a party to. We have cited a case in our brief that we believe is directly on point. It's the Thriving Investments LLC v. Chow case out of the 3rd DCA. It is directly on point. Third-party purchaser purchases a case at foreclosure sale, realizes that it is subject to a senior lien, and moves to the court to vacate the final judgment. The court in that case says the trial court properly held that the third-party purchaser was a stranger to the foreclosure action and lacked standing to vacate the final judgment of foreclosure. This appeal is accordingly dismissed because the general rule is that a non-party is a stranger to the record who cannot transfer jurisdiction to the appellate court. That is the exact scenario we are here before, Your Honor. We don't believe they have standing to even bring these arguments. Next, Your Honor, I do want to address the lack of transcript. There was an evidentiary hearing held on August 9th, 2023. The court heard testimony. As we know, in appellate proceedings, the decision of the trial court has the presumption of correctness, and the burden is on the appellant to prove or demonstrate error. Now, the appellant has cited two cases for why they believe this court can vacate an order or judgment if it's erroneous on its face. The two cases they cite, Calderon v. Calderon, Holmes v. Holmes, are divorce cases. Both of those cases involve alimony, child support. They are very distinguishable from what we are here for. The appellant has not actually cited any reason why that order from the lower court is erroneous on its face. It simply says denied. Without a record, this court can't understand what was argued, why the judge made its ruling. We don't think it's erroneous on its face. Without a record, the lower court's ruling has a presumption of correctness. So with that, Your Honors, if you don't have any questions for me, I will turn the rest of the time over to Mr. Wolf to address subject matter jurisdiction.
Thank you.
Good morning. Good morning. I'm pretty loud, so I hope you don't mind if I'm on the microphone. May it please the court, Matthew Wolf on behalf of RE 710. I want to focus on the subject matter jurisdiction argument in this case. This is the whole argument in the appellate brief. I want to cite from a sentence from the initial brief where the appellant argues that the determination of whether or not the trial court had subject matter jurisdiction to enter a foreclosure and the equitable lien foreclosure begins with the examination of the Lis Pendens statute 48.23. I disagree with that. I think whether or not the court has jurisdiction, that examination should begin with 34.01. 34.01 titled Jurisdiction of County Courts. Subject matter jurisdiction is the court's ability to hear and decide a case. That's conferred by our legislature through statute through 34.01, not 48.23. Any reliance on 48.23, I believe, is misguided. If we want to look at jurisdiction, you look at the jurisdictional statute. There's no argument here that this was within the jurisdictional confines of the county court. She just argued that 48.23 bars that. I disagree, and I think Your Honor, Judge Lucas asked earlier that this was probably a defense that could have been raised in the case, 48.23, but it doesn't go to the subject matter jurisdiction of the court. The court has jurisdiction under 34.01. Counsel relies heavily on the Quatermain case to argue that that there's a bar for enforcement and there's exclusive jurisdiction. I've read the Quatermain case. I've pulled every single brief that was filed in that case and every single filing in the trial court in that case. Quatermain was about a junior lien foreclosing a senior lien interest. Quatermain was a case where U.S. Bank foreclosed, failed to name the owner of the property because the owner died and the heirs took title. When U.S. Bank was a successful purchaser at the sale, they never actually took title. So when Quatermain, the homeowners association, files a lien and then sues U.S. Bank to foreclose the title owner, they never actually named the title owner. They named U.S. Bank. What the court said in Quatermain is U.S. Bank was the equitable assignee of itself. It stood in its own shoes to then go and do a re-foreclosure of the actual title owner. So when Quatermain filed suit, they were filing suit as a junior lien against a senior lien. And the court said, no, if you're going to do that, 48.23 says you have to intervene within 30 days, and you didn't do that here. That is the bar on the jurisdictional, that's the bar on the enforcement of that lien there. That's the Quatermain case. You don't have that here. What you have is a junior lien interest foreclosing on a homeowner. And that's where I studied the Jalali case. I think the Jalali case is what gives us better direction. It says the Lis Pendens statute, 48.23, says that the purpose of it is to protect the lender, not the homeowner. If you read it the way the counsel's reading it and the appellant is arguing, it will do nothing but protect the homeowner in this situation, saying, well, once a lawsuit's filed after 30 days, if there's a later acquired lien, if you go get your roof fixed and you don't pay for it, well, they're out of luck. They're never going to be able to file suit against you because you're now barred. That protects the homeowner. The Jalali case says, no. Lis Pendens statute protects the lender. And that's the situation we have here. Junior lien foreclosing on a homeowner doesn't affect the first lien. Counsel argued that I want to address some of her arguments. She argued that her client received nothing. It's not true. He received title to the property. Title's of record, it's in the record. He bid at auction. She says he has the unfortunate opportunity of being the successful bidder. And I think Your Honor asked, well, is there any record here showing that that mortgage was satisfied? If we look at the record of what he had knowledge of, if you look at the stipulation in this case that were followed by the parties, and you look at the judgment itself, it discloses that there's a senior mortgage. So even if he had not even looked in the official record to determine if there was a recorded mortgage or if there was a satisfaction, he should have at least been on notice of the final judgment that he was purchasing from. Paragraph 12 of the judgment. This judgment is subject to a superior mortgage foreclosure lien. This judgment does not eliminate any senior lien holder's rights, and any purchase of this property at foreclosure sale will be subject to a senior mortgage foreclosure lien. He had knowledge of this. He had knowledge of it in the official records. He had knowledge of it in this case. If he had taken 10 minutes to actually just review what he was bidding on, he would have discovered this. They're trying to argue the subject matter jurisdiction by shoehorning in the Lis Pendens statute, never once citing to 34.01, the jurisdictional statute of the county court. I don't think it holds water here. I don't think the court should overrule the trial court's ruling. In addition to the fact that, Your Honor, when you sat on the bench, you said, we're aware of the briefs, we've read them, and we've read your transcripts. You don't have a transcript in this case. We had a very long hearing on this matter. The order, I believe, is a one-sentence order saying the objection was denied. There's not enough here before this court to overturn the order. And if there's any questions, I'll entertain them now. If not, I would ask the court to uphold the trial court's order.
All right, sir. Thank you.
Thank you.
Counsel, you have 5 minutes.
Counsel mentioned the Fallon Rahima Jalali case from the 4th District Court of Appeal. And that case is also helpful to our argument. It follows Quatermain, and it it really has, the same factual situation that we're dealing with here, where the final judgment of foreclosure which the association obtained, was void because the trial court lacked jurisdiction at the time. And the court said that exclusive jurisdiction to foreclose on the property was in the circuit court conducting the mortgagee's foreclosure action. And in that case, they reversed the order denying the motion to vacate the final judgment of foreclosure. So under those 4th DCA line of cases, that supports our argument that there was no jurisdiction here. Also, the Adhen case from the 5th DCA is helpful to us because it uses the term jurisdictional statute of claim to describe 48.23. And in both cases, we're left with no other conclusion than the final judgment of foreclosure was void. Counsel referred to a couple cases that we did discuss in the reply brief, the YHT and Associates and the Thriving Investments cases. I would refer the court to our argument there, in which we distinguished those cases. With respect to standing, I would also refer the court to the arguments that we made in the briefs, that the third-party purchaser is the equitable assignee of BAM 32, and that standing really isn't an issue here at all. Clearly, there needs to be a remedy for a third-party purchaser. In this case, they put up a significant amount of money. They have been harmed. And if there is a judgment that is void, not only do they have standing to make that argument, but the court can also sua sponte, rule. The trial court certainly could have ruled that there was no jurisdiction, and this court likewise can rule that both the sale and the judgment are void. The Quatermain case, we think, is the facts are helpful to us in numerous respects. In that case, the association brought an equitable lien. They brought a foreclosure subsequent to the superior mortgage foreclosure being filed, and the court determined that the court in the association's lien case did not have jurisdiction. If the association had wanted to recover its fees, it needed to intervene in that superior mortgage foreclosure. So for all of the reasons that I've given you here today, we would ask that the court reverse the trial court. The trial court's order denying the amended motion to vacate, and the court hold that the sale should be vacated as void. Similarly, the final judgment of foreclosure. Thank you.
Thank you. We stay. Second case. City of Tampa versus. Yeah. Great.
Good morning.